right, welcome back to Claims and Sustains. I am Teddie Arnold.
I'm Erica Bakies.
I'm Ken Kanzawa. Today we're diving into the Supreme Court's decision in National Institutes of Health versus American Public Health Association, decided in August 2025. It's a technical case, but the implications for federal grants and for administrative law are really big.
Yeah, so let's start with the basics. What happened in this case? So following 3 executive orders, NIH revised its policies to state that it would no longer award grants involving diversity, equity, or inclusion initiatives or ones that dealt with gender identity or COVID-19. And then it applied that policy and terminated en masse a number of existing grants. The grant recipients whose grants were terminated sued in district court. They argued that the policy was arbitrary and capricious under the APA, the Administrative Procedures Act, and as a result, their terminated grants should be reinstated. The district court agreed and then vacated the NIH's guidance and ordered the NIH to reinstate those terminated grants. NIH appealed, eventually ending up at the Supreme Court asking for a stay of the district court's judgment. And the Supreme Court stepped in, but only sort of. The Supreme Court granted a partial stay. They stayed the district court's decision with respect to the grant terminations, but not with respect to the guidance. So Justices Roberts, Sotomayor, Kagan, and Jackson would have denied the application in full, while Justices Thomas, Alito, Gorsuch, and Kavanaugh would have granted it in full. So therefore, the opinion comes down to Justice Barrett, who would have granted the application as to the grant terminations, but denied as to the guidance. And this distinction has a basis in a jurisdictional analysis. So the majority of the court said that the district court had jurisdiction to hear the challenge to the agency's final actions under the APA, which is the guidance. But then they found that the district court did not have jurisdiction to hear the termination of the grant, which was a contractual challenge. And instead, the grant recipients were supposed to go to the Court of Federal Claims and under the Tucker Act and make their contractual arguments there. So, Teddie, what can you tell us about why there's this jurisdictional rift between the APA and the Tucker Act?
Well, first, it's nice to see all the justices on the Supreme Court in lockstep with each other. It's really nice when you get those unanimous decisions on really simple issues. So I think really what this highlights is the crux of the issue is when you've got a claim you want to assert. Where do you sue? So it really comes down to who has jurisdiction to hear your claim and to grant you the relief that you want to seek, right? So the world begins with sovereign immunity, okay? So Congress has created specific statutory waivers in instances where the government has waived sovereign immunity, so they can be sued in certain instances. In our world of government contracts, you're really looking at 2 ends of the spectrum: the Administrative Procedures Act, which was at the heart of this case. And on the other end, what we're all familiar with is the Contract Disputes Act and or the Tucker Act, both of which are sort of the complements to each other, right? Tucker Act sort of sits in the middle between the APA and the CDA. So different forums, different standards, they have different remedies. So first question is this a contract dispute arising under the Tucker Act or the CDA? Or is this an Administrative Procedures Act challenge? And the answer will shape your entire strategy in terms of what forum do you go to. You're either in district court under the APA, Court of Federal Claims under the Tucker Act or the CDA. Standards of review are different. You're either looking at contract interpretation on a pure contractual claim versus did the agency abuse its discretion in taking some kind of action, which was what the claimants here were alleging. And the remedies, really the big one too. Court of Federal Claims can only grant monetary relief. District court, under a contract theory, and a district court can only grant injunctive relief. The bridge that spans the two is both forums can grant declaratory relief, which was part of the relief being sought here. And so to sort of dig in just a little bit, the Tucker Act and the Contract Disputes Act, you both have to have a contract, right? It's a contract claim. The relief you would be seeking is money. To bring a claim under the Tucker Act, you have to identify some kind of money mandating source of law, right? If you've got a contract, monetary relief is presumed, right? If you have something else, if you've got a grant or a cooperative agreement, you've got to point to some other authority that would mandate money as the relief you're seeking in order to get jurisdiction at the Court of Federal Claims. Now, the Administrative Procedures Act, very different, right? So you're in district court. This governs the judicial review of a final agency action for which there's no other adequate remedy. So the point being, money will not solve my problem here. I need an injunction and a declaration that the final agency action is arbitrary and capricious. It exceeds the agency's authority. It's some kind of improper procedure, or it's an abuse of discretion, right? So the relief there is an injunctive relief or declaratory relief, or both in most instances. But the key being that there's no other adequate remedy that exists for you, and so you have to pursue your claims under the Administrative Procedures Act. So how do you determine what path you choose? Well, there's a test called the Rights and Remedies test, established under a case called Megapulse. And really it looks at two questions. Number one is, what is the source of the rights upon which your claims are based? Do they arise from statute, or is this some right that is part of your contract? Prong two is, what type of relief are you seeking, right? Are you seeking money, or are you disclaiming money, and are you seeking to enjoin the agency from doing something that you don't think they're permitted to do by law? Once you have established the answer to those two questions, you'll know what path you at least think you should pursue, and expect the government to really push back, as they did here, on the path that you've essentially chosen. So really, you've got at both ends, at each end of the spectrum, you've got district court, where you can seek injunctive relief. You've got the Court of Federal Claims, where you can seek monetary relief based on your contract. And there is a bit of a remedial gap that we'll get into in a little bit, that this case sort of highlights. But for now, do you want to talk about what Justice Gorsuch was essentially held in this case?
Sure thing. So both Justice Gorsuch and Justice Kavanaugh would have granted the government's application in full, meaning that they believed the entirety of this lawsuit believed at the Court of Federal Claims. Gorsuch says the district court was bound by an emergency SCOTUS ruling from earlier this year. It's called Department of Education versus California, also involved grant terminations. He called that case precedent that the lower court should have followed, and he said that even though California was, like this one, a probabilistic holding on interim relief. So what I mean by that is that in California, the court granted a stay because it found the government likely to prevail in showing that a district court lacked jurisdiction to order the government to pay grant obligations. The reasoning there was that suits based on an express or implied contract belong in the Court of Federal Claims under the Tucker Act, and because the APA cannot be invoked to pay money. Gorsuch rejects the district court's attempt to distinguish California on grounds that it concerns the denial of previously awarded discretionary grants, saying that the injury in NIH in this case also stemmed from the denial of previously awarded discretionary grants. He also rejects the First Circuit's attempt to distinguish California. The First Circuit had suggested that the APA had been invoked not to pay money, but to vacate the government's termination decision. But Gorsuch equates that order. He equates vacating grant terminations with an order that requires the payment of money. The First Circuit also had distinguished California by stating that the claims in NIH do not depend on the terms and conditions of the grant awards, but Gorsuch stated that the injury and the alleged right to payment actually stemmed from the terms and conditions of the grants. So he believed that basis for distinguishing California also was inapt. Now, Kavanaugh, he also agreed that challenges to grant terminations belong at the Court of Federal Claims, consistent with California, but he also found that the plaintiff's challenges to the guidance in the grant terminations was likely unavailing. To Kavanaugh, it's not clear that a challenge to the guidance is separable from a challenge to the grant terminations, but even if so, he states that the plaintiffs are not likely to succeed on the merits of their challenge because there was no requirement for DEI, this is something Erica mentioned earlier, to be defined under the APA, and that was the district court's principal criticism of the guidance documents. Kavanaugh also believed that the balance of the harms tipped in favor of the government because the plaintiffs had not represented that they would return the grant money if the government were to ultimately prevail.
Yeah, so it sounds like Gorsuch is saying all of this comes down to what do you need to get paid for this wrongful termination. And so you're squarely at COF C under the Tucker Act. And Kavanaugh, it seems like, agrees, but also maybe takes it even a step further and says, hey, even if we were to look at the merits of this, you plaintiffs are going to lose, so you're not entitled to injunctive relief here. On the flip side, the justices who would have denied the application in full and allowed the district court to proceed with both the challenge to the guidance and the grant terminations kept it short and sweet. They said in Department of Education v. California, the only relief that the plaintiffs were seeking was monetary. Here, though, they said that's not the case. Here, the plaintiffs are seeking to invalidate the guidance as arbitrary and capricious, and as a result of that, reinstate their grants. They very much distinguished between reinstatement of the grant and payment of money, saying reinstatement of the grant is not necessarily payment of the money, even though that's obviously what flows from it. So they argue that the challenge to the guidance cannot be disentangled from the termination of the grant. The real relief being sought here is the invalidation of the guidance and the resulting termination of their grants. Separately, Justice Jackson explores the practical outcomes of the court's decision here, and they're really interesting. So she refers to the outcome of the decision today as a jurisdictional labyrinth. Her main concern is that by splitting these claims between the district court and the Court of Federal Claims, grantees can never really get whole. To start, she assumes the plaintiffs win on their argument that the NIH's guidance is arbitrary and capricious. But then she says, so what? Indeed, she points out that Justice Barrett suggests the plaintiffs could go to COFC at that point and seek relief, right? Because you can't, there's statutory law that says you can't file simultaneous actions based on the same facts. So there's a question of whether you'd have to go at the same time or you'd have to file one involuntary APA action and then follow up with your Tucker Act contract claim separately. But in any event, Justice Barrett suggests the plaintiffs have to go to COFC after they get this APA ruling. But even then, Justice Jackson asserts that COFC's power to provide monetary damages does not extend the reinstatement of grants. So if you go to COFC, you're getting your termination costs that aren't paid, your performance costs to the extent those haven't been paid, typical termination disputes. You're not getting the multitude of money that you were promised by the government to continue your medical trial or your study. So Justice Jackson ultimately concludes that this is a classic example of the law offering remedies in theory but not in practice. The Court of Federal Claims can write you a check, but it can't restart your research project. The district court can strike down a policy, but it can't restore your funding.
So this is that remedial gap I'm talking about, right? So you can get money, whatever your money damages you can show from your grant being terminated. You can get those at the Court of Federal Claims. Maybe in district court, you can still get a declaration that the agency has acted unlawfully in issuing these policy documents. But neither of those sound like reinstatement of your grant. That is the gap, and I think that's the remedial gap that Justice is talking about there.
Yeah, she's basically saying plaintiffs at this point can never be made whole.
Yeah, exactly.
Despite agency in improper action.
It's interesting. This is this tension between the Administrative Procedures Act and the Tucker Act. This is not really new. This is an interesting decision, but this has gone back decades. There's a case called Bowen versus Massachusetts, in which it initially looked like the door was open for government contractors to bring claims in district court. In that case, the state of Massachusetts had sought payments for Medicaid, and they were disallowed. And HHS essentially was the agency who made the decision to disallow certain expenditures. And the state of Massachusetts went to district court, sued under the APA. The government, as they normally do, they filed a motion to dismiss, said you're seeking money, right? You didn't get paid your Medicaid reimbursement. It's a monetary claim. You're in the wrong forum. And in that case, the district court, and this is back in 1988, the district court said, no. Actually, what they're seeking really is an equitable remedy. Court of Federal Claims has no injunctive powers to stop the agency from doing what it's doing. So you can only seek that relief here, right? So they retain jurisdiction. So that sounded promising. In the ensuing years, that has been narrowed. There's a case called Department of Army versus Blue Fox in 1999. That was a subcontractor who hadn't been paid, was trying to sort of pursue the same path, seeking equitable relief in district court. And in that case, the district court said, no, this really is your claim that you didn't get paid. and it went through all the analysis and ultimately came out that equitable relief is not appropriate because this all flows. It's a grievance you have under your contract. It's a contract claim. Court of Federal Claims is exclusive jurisdiction. So, not the debate will continue to rage on, especially given that it's clear here that there's lapses in the types of relief that can be afforded to certain claimants.
So that brings us to our next topic. Why do courts draw this line? Why does the Supreme Court draw this line, rather? Well, think of the federal budget as a giant pool of taxpayer dollars. Congress doesn't want that pool to be drained unpredictably by dozens of district court judges in different states reinstating grants or contracts. That's why Congress created the Court of Federal Claims to be the gatekeeper for fiscal claims. And that's for two big reasons. First is budget discipline. Injunctions could scramble how agencies allocate money. Damages are more predictable. Second is sovereign immunity. Again, the government only can be sued if it consents to be sued. Here, the Tucker Act is that consent, but it's narrowly tailored to money. So by funneling disputes like this into the Tucker Act box, the court is protecting the Treasury, even if that leaves grantees without the relief that they really want. And that shows a trade-off here, right? Fairness for individuals versus stability for government finances. And that's why the remedial gap exists. It's not an accident. It's a conscientious design choice to shield the Treasury.
Yeah, by Congress. And I think that is interesting because this split also falls over into the court's discussion about injunctive relief and who's having irreparable harm here, who has the irreparable harm. So the majority of the court says, listen, normally money is not enough to show irreparable harm, but here it is. And that is consistent with the majority's position that this is in fact a case about money, right? And so the majority says that the plaintiffs do not state that they will repay the grant money if the government ultimately prevails. So they said that's enough. You have irreparable harm, government. On the flip side, Justice Jackson would find that the government had not demonstrated irreparable harm, and this is for two main reasons. First, she points out that the government already promised to these grant recipients the money. So any amounts that the government would pay while this litigation is ongoing is already following an obligation that the government itself undertook. And second, she says the payments aren't harm to the government so much as a consequence of the government's own decision to terminate the grants. So she says, I'm not convinced about the money issue. Instead, she says the plaintiffs will face irreparable harm. They can't restart their studies, they can't restart their trials, and therefore this harms science and this harms the public that benefits from the science. And Justice Jackson also notes that this is not a unique situation that's limited to the grants at issue in the case, but instead, because as Justice Gorsuch has pointed out, this is a apparently binding precedent that would apply to any other grants in similar situations under other government policies. So this discussion is interesting because it also, frankly, tracks what the administration has been saying, which is we want bonds from plaintiffs. If you're going to get an injunction, we want to be protected on a monetary basis. So it is good practice moving forward if you're going to take on these cases to maybe consider a bond on the plaintiff's side so that you can demonstrate that the government, in fact, will not result in irreparable harm and that your grant being terminated improperly would result in irreparable harm. So it's a really interesting case.
So what are we left with here? All right. So I don't know that it's the nail in the coffin. I think it's certainly not great for grantees who've had their grants terminated, right? Really the relief that the Supreme Court ordered here was a stay of the district court's decision, which on at least on the grant terminations, which was a victory for the government. They declined the stay on consideration of the policy documents, whether those were unlawful. So that's a victory for the claimants. But ultimately here, does not seem like these grants are being reinstated anytime soon. The fact that you have two forums to go to, that it's sort of this bifurcated process, is something that grantees can cling to. They know they've got a path to seek monetary relief. You know you've got a path to pursue unlawful agency action. But as we've seen, and you can't bring this at the same time, that could take years, right? I mean, the process of going to both forums could collectively take a decade or longer. So Not great news for grantees, but certainly limited to the facts of this case, and I think certainly something to keep an eye on as other merits cases get decided, because these are fairly factually nuanced decisions as to sort of what type of claim are you asserting and what's the proper form that can take jurisdiction over that claim.
Yeah, I think Justice Jackson makes that point in her separate writings. She says, listen, we've had no time to consider any of this, and we need to let this percolate among the courts. And it's, to your point, very highly fact-specific. So let's get some opinions out there before we carve out this jurisdictional quagmire and force these claimants to go to multiple jurisdictions to seek relief. So thank you very much for joining us on this episode of Claims and Sustains. We hope you appreciated our conversation, and until next time.